Best. Students in the online very good. Good afternoon, all of you. Both are who are on physically and both who are on online appearing to this session. Welcome to this one. Our director of the academy assigned to me. Is it audible to you all? No problem. Assigned to me today an interesting topic to interact with you. That is one of the three newly enactments on criminal law. That is, all of you know, Bharatiya Nagarik Suraksha Samhit. Old law was Criminal Procedure Code. Bharatiya Saksha Adhinayam, Indian Evidence Act previously. Indian Penal Code, which is Bharatiya Nyaya Samhita. Nyaya Samhita is the replica for Indian Penal Code. All these three enactments, all of you know, have been brought forth with effect from 1/7/2024. Today, we will interact on the main aspect, that is Bharatiya Nyaya Indian Penal Code. Under what circumstances, of course, the three enactments were brought. Most importantly, under what circumstances this particular enactment, Bharatiya Nyaya Samhita, was brought forth. Why Indian Penal Code was repealed? It was repealed, isn't it? Section 358 would say the repealing and saving provisions. Bharatiya Indian Penal Code was repealed with effect from 1/7/2024. Okay, so we have to see the background history. minutely. Under what circumstances the Indian Penal Code was repealed and this new enactment was brought? What was the requirement to do so? And what are the important facets? What are the point of view of the examination? Junior maybe public prosecutors or maybe for the district judges who are going to take up the examinations. To them also, it will be beneficial to them to have a hind history. Hind history means backward history. We'll discuss them in a thumbnail sketch. But before that, it is also imperative to know the background history of under what circumstances Indian Penal Code itself was brought forth. It's not it. Have you ever thought of why Indian Penal Code was brought before us? What were the circumstances that was prevailing? Because those were complex situations where India was under the British rule at that time. Is not it? India is not a free country like in the present circumstances when BNS was brought. It was under the British rule. And go back to those circumstances which necessitated the British government to bring the Indian Penal Code. What they wanted to achieve from the Indian Penal Code. What are the aspects of the Indian Penal Code? If you are able to just know the crucial facts at least relating to Indian Penal Code, I think you will be in a position to better understand now why the BNS was brought. There is a link between the two situations. Indian Penal Code, the circumstances under which it was brought, it lost from 1962. 1862, it is January 1st, isn't it? Indian Penal Code was brought forth from 1862 and it is continued in our country for more than a century up till 2024. You see how much time? 1861 means 62 means 38 plus 100 plus 24, almost 160. It ruled without any major problems. During the British realm, the independence realm, thereafter advanced science and technology has come, still Indian Penal Code was prevailed. It's a very classic enactment, like Transfer of Property Act, like a Contract Act. These are all the classic laws which were given by the British legacy. British jurisprudence, Anglo-Saxon jurisprudence has given us these laws. One such law is the Indian Penal Code, which ruled the roost for the entire country. So under what circumstances it was brought is important. I will briefly tell about the background history relating to Indian Penal Code. Is it? You have to slightly go back to 1833. At that time, what was the circumstances prevailing? At that time, India was under the control of British East India Company. East India Company came to India only to do business at first, but it has much navigational force. It has much military force also. Slowly, they went to the kings and on the contract of supplying the military force to protect their kingdoms, etc. They obtained some lands, etc. And slowly they started wielding power over the Indian kings. Because at that time Indian kings were not united. Each Jamindari, each Samsthan were divided. There is no like Akhanda Bharat or like now we have the India. India was there, kings were there, each king was having his own kingdom. There is not like a union between among the Indian kings. Okay, that is political history. The relevant fact relating to Indian Penal Code was that by 1833, the situation was that British East India Company was essentially doing the business here. That means it was bringing the goods through ships to India and marketing them. From India, they were exporting స్పైసెస్ అంటే ముఖ్యంగా యాలకులు, లవంగాలు కేరళలో మనకి ఎక్కువగా దొరుకుతాయి. ఇవి అదర్ కంట్రీస్లో వాస్కో డ గామా ఆల్సో కేమ్ టు ఇండియా ఓన్లీ ఫర్ ద పర్పస్ ఆఫ్ ఫైండింగ్ ఎ మార్కెట్ ఫర్ స్పైసెస్. దట్ ఈస్ వై హీ కేమ్ ఫ్రమ్ గోవా టు దట్ కొచ్చిన్లో పెద్ద ఆయన తాలూకా ఇది ఉంటుంది, డెడ్ బాడీని బరీ చేసిన ప్లేస్ ఉంటుంది. ఇఫ్ యూ హ్యాపన్ టు గో టు ద కొచ్చిన్, you will find the Vasco da Gama's mortal remains over there, like a church you will find. So it was essentially doing the business, but slowly captured the Indian administration also. But with the blessings of the British Queen, any Britishers used to come to other countries means have to get the permission of the Queen at that time, British Queen. That is called as letters patent. Letters patent means a patenting. It's like a certificate, authority. You go to other country, you do business, but you are going on behalf of our country. You have to pay taxes to me. That means to the England. That was the condition. America also. America was originally decided by the Red Indians, like a tribals. Mana Paderu, Khammam area lo unde tribals lat valle. Red Indians. Originally it was inhabited by Red Indians. But these navigation, because Britishers have expert navigation in seas, no other country had at that time. So they used to go from one continent to another continent. Through Atlantic Ocean, they discovered the America. Columbus discovered the America. So then they went there, they sent away the tribals and they occupied, they started doing the business. Slowly they set up the colonies. Like in India also they started colonies. This was the history. Thereafter, they started paying taxes to the government. Sometime they raised a revolution that why should we pay taxes to the Queen? What benefit we are getting? We are doing the business here, for which no amount was given to us, nothing except giving the permission. So in 1774, they declared independence. That is called as Declaration of Independence by the Americans. There were already 33 to 34. Ivanni kuda mere American Constitution chadivite, American history chadivite meeku telustundi. I am only incidentally telling what is the background history of Indian Penal Code. Please. At that time, in 1774, 32 or 33 colonies independence, they sent a draft declaration of independence. It is called as declaration. That declaration was signed by some 32 to 33 colonies, British colonies. We declare independence. It was drafted by none other than, if you go to the American history, it was drafted by, so most of the out of 32 to 33 British colonies represented mostly by the advocates. You know the role of the advocates. They are not mere advocates. They fought for freedom like in India. They fought for the freedom in America also. Out of 32 or 33, 25 are represented by the advocates. The draft was drafted by none other than Thomas Jefferson. Thomas Jefferson was the third president of India. If you happen to visit Washington, you will find only 3 monuments. One is for first president of India, Washington. Second is the second president of India. Who is that? Abraham Lincoln, because he fought for slavery abolition. The third monument, మూడే monument ఉంటాయి అక్కడ, ఇన్ని వందలు ఉండవు విగ్రహాలు అక్కడ. 3 monuments you will find in Washington. If you happen to see the capital town of the Washington Parliament ఉంటుంది, దానికి ఇటు 3 కిలోమీటర్ల దూరంలో 3 monuments you will find. One is meant for Washington. George Washington is the first president of America. Second is for the Abraham Lincoln. He fought for the blacks, slavery violation, the abolition. Third one is for Thomas Jefferson, because he fought for Bill of Rights. అప్పటికి వాళ్ళకి ఫండమెంటల్ రైట్స్ అంటూ ఇంక్లూడ్ చేయలేదు. అమెరికా ఇండిపెండెన్స్ వచ్చిన ఇమీడియట్ బిల్ ఆఫ్ రైట్స్ లేవు. ఇట్ ఈస్ ఓన్లీ 10th amendment ఆఫ్ ది కాన్స్టిట్యూషన్, 3rd నుంచి 10th amendment ఆఫ్ కాన్స్టిట్యూషన్ వచ్చినప్పుడు బిల్ ఆఫ్ రైట్స్, మనకి ఏదైతే ఫండమెంటల్ రైట్స్ మనం అంటామో మనకి కాన్స్టిట్యూషన్ రాగానే ఇచ్చారు. 1950లో మనం అడాప్ట్ చేసుకున్న కాన్స్టిట్యూషన్లో చాప్టర్ 3 ఈజ్ ఫ్రమ్ ఆర్టికల్ 12 to 35 ఫండమెంటల్ రైట్ ఫ్రమ్ బిగినింగ్ వీఆర్ హ్యావింగ్, బట్ ఇన్ అమెరికా దే హ్యాడ్ నో. It is only after amendment of the constitutions, the Bill of Rights were included with the voice of Thomas Jefferson. Immediate next president they had Lucky, that was continued by Madison. Madison was the 4th president of America. 3rd and 4th presidents were very visionaries. People should have the Bill of Rights under. Manamaithe fundamental rights antam, what Bill of Rights under. Bill of Rights were introduced in 3rd to 10th amendments to the Constitution. That is why they are the fathers of the nation, fathers of the Constitution for their country. So that was the American. The same type in India, what happened? 1833, the situation was that first Muslims have invaded India and they established their kingdom, Babur or Akbar, thereafter, so on and so forth. When British regime was there, what was the law prevailing here, particularly for treating the offences? Before that, what law was there? Before Muslims invasion in India, our penal laws and civil laws were controlled by the Smritis, codes. First is Manusmriti, second is Yajnavalkya Smriti, then is Kautilya's Arthasastra. These contained some guidelines how to deal with offences, how to deal with civil laws, marriage, divorce, aspects were also there, how to collect taxes, etc. So everything was there in the manuscript. Then Yajnavalkya Smriti, Yajnavalkya was a hermit, a sage, ఒక ఋషి, ఆయన రాసిన కోడ్స్లో అట్లాగే అర్థశాస్త్ర. Thereafter Muslims ruled India for about 10th or 11th century to up to 15th or 16th century. During this period, they introduced certain laws, Muhammadan laws, mainly Quran and some other sources of Muslim law, wherein they also prescribed administration of justice. Administration of justice were under their control. Particularly the criminal law, also 4 types was there. Okay, if you want, this is the history of criminology in India. During the Muslims regime, 4 types of punishments were prescribed according to their texts. What is those texts are, for your if you want, I can tell. First type of punishment is kissa, K-I-S-A, kissa they call it. Kissa is a punishment given for eye for tooth. Murder for murder means if a person kills another person, that man should be punished with it. It is a two type of punishment. 4 types of punishments में jurisprudence was there. This is similar to this type of punishment. So certain types of offences, this kissa type of punishment was provided, a retaliatory. నువ్వు అది చేస్తే నీకు ఈక్వల్ పనిష్మెంట్ ఇవ్వడం అనే ఒక సిస్టమ్. Second one is hadd, HADD, hadd type of punishment. This is something a lesser type. How it is, certain category of offences, there are prescribed offences are provided, just like an Indian Penal Code. Theft, this type of years, a robbery, some up to life, robbery coupled with death, imprisonment for life, rape, this type of punishment. So particular some type of offences, some type of punishments are prescribed. They were used to provide. So first is kissa, second is the hadd, third is tazir, T-A-Z-E-E, or tazir is certain type of offences. There is no specific type of punishment. It all depends upon the discretion of the king and local qazi. Qazis means who are administering the law in a gram panchayat level. That is left to their discretion. ఇప్పుడు కూడా మ్యాజిస్ట్రేట్ గారికి ఏముంది, ఒక్కొక్కసారి either కార్పొరల్ పనిష్మెంట్ ఆర్ ఫైన్ ఆర్ బోత్ అన్నప్పుడు మ్యాజిస్ట్రేట్ గారు తన డిస్క్రిప్షన్తో కొన్ని ఐపీఎస్లో ఒక డిస్క్రిప్షన్ ఏం చేస్తారు, ఓకే దిస్ ఈస్ అ మైనర్ అఫెన్స్, ఐ విల్ లెట్ హిమ్ ఆఫ్ విత్ ఫైన్. కూడా ఆ సిస్టమ్ ఉంది, అక్కడ కూడా ఆ సిస్టమ్ ఉండేది, పర్టికులర్లీ మైనర్ టైప్ ఆఫ్ అఫెన్సెస్, ఎయిదర్ బాడీలీ పనిష్మెంట్ ఆర్ ఫైన్ ఆర్ both. That used to come under TAS. So these mainly three types of punishments were administered under the Muslim regime. This was the situation. Even in some areas where Muslim regime was not very prominent, Hindu type of texts used to be followed for punishments, etc. Suppose in that area domination is by Hindus, some Hindu అంటే ఖాజీ ఈక్వలెంట్గా ఎవరైనా గ్రామ పంచాయత్ పెద్దలు ఉంటే they used to follow the Indian text, Hindu text, and used to give punishment. So what I want to tell you is there was no specific uniform system of administration of justice, particularly in criminal side. We are not concerned with the civil administration, but criminal justice system by 1800 and 1830, by that time there was no uniform system prevailing in India. At that time British government, seeing that the East India Company is only a company meant for doing the business, but slowly they captured administration also. They didn't know the administration very well, particularly the administration of justice. If this is the situation, there will be an unrest in the country. They will fight for freedom. That was the fear for the British government. So they thought that no, this will not do. We have to send a strong ruler who will take over the administration and leave the business and merchandise to the East India Company. They thought it. They said they already had one Governor General for Bengal. He was already there only for Bengal. Very able administrator, proved to be very able administrator in Bengal. He is none other than William Bentinck. William Bentinck was the Governor General on behalf of the England, British government in Bengal. They made him a Governor General for the entire country. Understand? Because a chief minister was made as a prime minister for the entire country to rule. Just like that, William Bentinck was a governor only West Bengal. There's nothing like West Bengal or East Bengal. It was a Bengal province. He was made as a Governor General, for the first Governor General for the entire country. They have given the full powers to administrate, to make laws also. That is most important. For our purpose, what is important is he was given powers to make laws so that the country will be administered smoothly. Understand? So William Bentinck took over the powers, reigns when Pagal తీసుకున్నాడు. ఇప్పుడు 1834 also. He first saw that country was having social problems, political problems, educational problems, and administration of justice problems, judicial problems. See, one after another he was tackling it. First, his social problem is, at that time sati means when a husband dies, woman was forcibly to enter on the funeral pile. This he saw it is a very, very rude practice. We should abolish it. Sati abolition was introduced by him. It is a great social reform. It was questioned in a court of law. It went up to the Privy Council. Privy Council held that no, it should be abolished. He is one of the great reformers. He introduced the sati abolition. That is on social side. Education side, they introduced Persian during Muslim times, regime. Persian, Urdu, etc., which was native Indians did not know Persian, or even Urdu also to some extent. Majority of the people didn't know. They knew only Sanskrit and Indian languages. There was no common language in the entire country. So he first of all introduced during his regime only, English was introduced as the common language for the entire country for easy uh, exchange of the views and exchange of the interaction, etc. He introduced. This is one of the reforms, education side. Not only that, what we are now seeing UPSC, APPSC, Union Public Service Commission, different type of introducing native Indians into the jobs of the British government. At the till then, there was no Indian in the government public servants. Public service, there were no IAS, IPS, forest service or other service. No question Indians were not admitted into the public services, government services. At that time, the British government thought it that these Indians are not able to do the jobs, they have no knowledge, etc. But he felt no. Given an opportunity, it is their country we are ruling, and all other native circumstances. If you impart mathematics, arithmetic, etc., in followed in Europe, etc., they can be assistants. Of course, they were introduced only lower jobs like clerical jobs. They were not given administrative heads are only IAS. అందుకనే మనకి స్వాతంత్రం రాకముందు వచ్చిన కొత్తలో ఉండే వాళ్ళందరూ కూడా బ్రిటిష్ కలెక్టర్స్. చిత్తూరు అటుపక్క వెళ్తే ఇంకా నగిరి అటుపక్క వెళ్తే కూడా ఇప్పటికీ కూడా కలెక్టర్స్ పేర్లన్నీ కూడా హార్స్లీ హిల్స్ ఎవరు ఉండేవారు? Collector Athanu, he was the British. High posts were ruled by the Britishers, at least lower cadre thrown open to the native Indians. This is some sort of amendment or reform he brought so that Indians could get jobs in their country in public service. This is one type of amendment. The next and most important, which is relevant for our purpose, why Indian Penal Code has brought into force. He saw this type of punishments provided one up to some part basing on the personal laws of Hindus. Criminal offences were dealt with and punishments were provided. Manusmriti or Smriti or so. It was not uniform throughout the country. After some time, basing on the personal laws of Mohammedans, Muslim laws, basing on what punishments are provided, this is also not uniform throughout the country. So there is no uniform law for prescribing what is a particular offense. Offense means you need a definition, isn't it? Theft means what? What do you mean by theft? 379, okay, go back to IPC. What is theft definition? Can any of you? What is the definition of theft? Any of you can? Online or offline? What is a theft? Definition 378, 379 is the punishment provided. A dishonest intention, with a dishonest intention, moving a movable property from out of the possession of one person. A dishonest intention must be there. Dishonest means, again, definition is given for dishonest. To cause a wrongful loss to one person and wrongful gain to me. Suppose this is your cell phone, this is yours. I had a dishonest intention. I have moved it with a dishonest intention to deprive the possession from you and to cause a wrongful gain to me and wrongful loss to you. I have moved this property. That is sufficient to commit theft. There must be dishonest intention on the part of the accused to cause a wrongful loss to the owner and wrongful gain to him. If he moves that property from out of the possession of that man, it is wrongful. This is causing theft. So for every offense, for example, dacoity, robbery, rape, murder, for everything there used to be definitions. But in all, there was no systematic definitions for offenses in Indian criminal administration system at that time. That he has saw, that he has seen. Who? William Bentinck. This is more dangerous. You are taking away his life and liberty, but without prescribing what is the offense is. మన ముందు అఫెన్స్ చేశాడంటే మన కోర్టులో ఏం చేస్తారు? హ్యావ్ యూ ఎవర్ అబ్జర్వ్? హ్యావ్ యూ ప్రాక్టీస్డ్ ఆర్ యూ హ్యావ్ నాట్ Any of you practicing, or you are students only? With other students, sir. See, if you happen to be a practitioner, particularly criminal law, first of all, what the court will do is, the police filed a charge sheet. Suppose a person has committed a murder. A committed murder of B. So A against a FIR was lodged in the police station by the relatives of B. Police then conducted investigation. During investigation, they arrested him. They sent him to the judicial remand. Who have seen XYZ have seen causing him with a knife, etc. Okay, they have collected the evidence from them. They prepared 161 statements. They prepared a material. They are then basing on that material. They prepared a charge sheet. Charge sheet means these eyewitnesses have stated that this man on the day at a particular place pierced him. Therefore, he suffered grave injury and died on the next day or immediately, whatever it may be. Therefore, he committed an offense under 302 murder. This is the challan or charge sheet they will prepare. Doctor has given the certificate, that post-mortem certificate. This knife can cause the death. All intestines or duodenum, etc. So post-mortem. So the material they will place is called as the charge sheet. Then it appears before the court. That accused will appear. Court, what it will do? Court will prepare a charge. Look, the police brought an allegation against you that on so-and-so date, at so-and-so time, at so-and-so place, you, because of certain previous disputes with B, has committed murder of him by intentionally piercing him into his stomach with a knife and thereby caused his death, and your act is called as a murder within the definition of 302. What do you say with regard to the charge? He may say, I have not committed a murder, let the trial go on. The court will prepare the charge under 302. So what we are now doing, if we make an allegation against a criminal allegation against a person, the court will first of all frame a charge. This is under section 227 of CRPC, Sessions Trial. That is called 227 to 238. This chapter, Sessions Trial, murder cases, పెద్ద సెషన్స్ అఫెన్సెస్ ఆ చాప్టర్ కిందే డీల్ చేసేవాడు. ఇప్పుడు ఆఫ్ కోర్స్ ఎన్ఎస్ఎస్ వచ్చింది, ఈక్వలెంట్ గానే ఉంది, సెక్షన్స్ మారాయి అంతే. ఓకే, వాట్ ఐఎమ్ టెల్లింగ్ ఈస్, ఇన్ ఓల్డెన్ డేస్, during that 1833, there is no proper definition, because 302 offense of murder means there is a definition. According to that definition, you have committed this act, therefore your act falls within the definition of murder. The court will tell him. Why this exercise? The accused must know what is the offense I have committed, what is the wrong I have committed. According to the court and police, this is the wrong. Okay, I will defend myself. అంటే నా మీద అభియోగం ఏంటో నాకు పూర్తిగా తెలిస్తే కదా నేను నన్ను డిఫెండ్ చేసుకోగలను. కెన్ ఐ బి charged for an offense of murder and can be punished for an offense of rape? Cannot be. You have framed a charge for murder. You have to try me and punish me for that offense, but not a different offense. So at that time, previously, there were no definitions, there was no criminal procedure code or Indian Penal Code. This was the major difficulty in administration of criminal justice system. For this purpose, what Bintek did is, okay, there is a requirement of preparing a law, a penal law for administering entire the country. Therefore, first of all, he set up a law commission. ఇప్పుడు కూడా లా కమిషన్ ఆఫ్ ఇండియా ఉంటుంది. దట్ ఈస్ రిప్రజెంటెడ్ బై retired chief justice or a retired Supreme Court judge, mainly Supreme Court judges. మన తెలుగు వాళ్ళు కూడా ఎంతో మంది సుప్రీం కోర్ట్ జడ్జెస్, ఆనరబుల్ సుప్రీం కోర్ట్ జడ్జెస్ లా కమిషన్ చేశారు. జస్టిస్ జగన్నాథరావు గారు చేశారు. తర్వాత మన ఆంధ్రప్రదేశ్కి హైకోర్టు జడ్జిగా ఉండి తర్వాత సుప్రీంకోర్టు అయ్యారు లక్ష్మణన్ గారు, డాక్టర్ లక్ష్మణన్ గారు చేశారు. లా కమిషన్ ఈజ్ ద కమిషన్ It is a body appointed by the central government to study various laws prevailing in India and give suggestions to గవర్నమెంట్ టు మేక్ న్యూ లాస్. అలా చేసిందే ఈ ఇండియన్ పీనల్ కోడ్ని తీసేసి ఇప్పుడు వచ్చిన 3 లాస్ కూడా. లా కమిషన్ ఇచ్చిన రిపోర్ట్లను బేస్ చేసుకుని ఇది మళ్ళా చేశారు. వి విల్ కమ్ టు దట్ వన్. సో హీ ఫెల్ట్ ద నీడ్ ఆఫ్ ఏ లా కమిషన్. Therefore, William Bentinck introduced the system of law commission for the first time in 1834. That law commission is headed by T.B. Macaulay. That Macaulay gave us the Indian Penal Code for us. Understand? This T.B. Macaulay and associate some other members who also given him, but basically he was the chairperson of Law Commission. And William Bentinck requested him to prepare a draft, codify a criminal code, means for punishment of offences for applicable to throughout the country. That committee 1800 and up to 1856 they studied throughout the length and breadth of the country. They have studied various things, what types of offences are prevailing in our country. They studied and then they prepared the Indian Penal Code. They submitted it in 1856. 1856 kalla British government ki ichchesaru tayar chesi. 4 years they studied it. What is this recommendation made by a committee has given it? They intensely studied in British. Then in 1862 with effect from 1st January 1862. That is how Indian Penal Code. So the main object is to give effect to the entire country one uniform code. This is the most important. Theft in Andhra Pradesh lo chesina, Maharashtra lo chesina, Madhya Pradesh lo chesina, or any other place, that act is defined and theft is a theft through. It is not basing on any personal laws like Hindu code or Muslim code or some other code. It purely based on the definition basis. A definition is given for every offense. If your act falls within that pigeon hole, ante aa groove lo padite, this is a offense. If it not fit into that groove, you have not committed any offense. Go back. That is set free under court of law. So this is how Indian Penal Code was drafted and submitted, and it was adapted by the British government, applicable to throughout the country with effect from 1/1/1862. This Indian Penal Code, you all know, consisting of 23 chapters. Okay, 23 chapters, 511 sections. Okay, నిన్నటి వరకు ఉండే అంటే లాస్ట్ ఇయర్ వరకు ఉండే ఇండియన్ పెనల్ కోడ్లో it consisted of 23 chapters. Each chapter related to a particular aspect. For example, section 299 to section 372 వరకు వచ్చిందంతా offenses relating to body అని సార్. Body offenses అంటే murder, then what you call murder causing grievous injury, civil injury, start చేసుకుంటూ ఉంటే 299, 300, 301, 302. These are all offense of murder related. Then comes 319, 20 వచ్చేసి 20 grievous injury definition, 321, 322, 323 నుంచి simple hurt, 324 grievous injuries, 325, 326 grievous injuries with a deadly weapon. So a very minute and a systematic arrangement of sections, if you carefully look into it. 299 to 372 వరకు ఉండే కూడా offenses against the body. అందులోనే బాడీ రిలేటింగ్ టు అఫెన్స్ ఆఫ్ వాట్ యు కాల్ అది రెండిట్లోనే పడతాయి. అఫెన్స్ ఆఫ్ రాబరీ మే బి ఏ offense relating to property, but offense of robbery or dacoity associated with murder or causing injury, again it is a common offense for offenses against the property as well as offenses against the body. So 511 sections are couched in different groups. Each group or each chapter is relating to a particular aspect. Similarly, if you see what you call 300 and 400 and 378 to 462 against property. 378 అంటే నేను ఇందాక చెప్పాను స్టార్ట్ అవుతుంది. 378 start with theft, then dacoity, robbery, so on and so forth. Cheating also అందులోనే వస్తుంది. Cheating, తర్వాత criminal misappropriation. These are all the offenses relating to property. So broad classification is offenses against body, offenses against the offenses against the property. Third category is offenses relating to marital offenses. Having a second marriage during the subsistence of the first marriage, 494. 498A relating to marital subsistence ఉన్నప్పుడు causing the cruelty, legal cruelty towards the other spouse. ఆమెని కట్నం కోసం వేధించడం, తర్వాత వాల్యుబుల్స్ తేమనమని బాధించడం, 498A. 497, of course, that has been taken away from the statute book. 497 is adultery with a married woman, having illicit intimacy with another married woman by another person, knowing that that lady is a wife of another person. This man used to be punished. Of course, that has been taken away from the statute book. We will discuss. So what I want to tell is, entire Indian Penal Code is divided into separate chapters, 23 chapters. Each chapter is meant for a particular aspect of crime. Section 76 to almost 106, what are they? They are relating to exceptions, general exceptions. Even if a particular person committed an act which otherwise an offense, but if it falls within this exception, he shall not be punished. Right of private defense. దొంగవాడు వస్తాడు అర్ధరాత్రి డబ్బు పట్టుకుపోవడానికి వచ్చి మీ భయపెడతాడు మిమ్మల్ని. టు సేవ్ యూ, you can cause him injury. At times, depending upon his act, you can cause his death also. What is otherwise a murder, but in the context of exercising the right of private defense, it is not an offense because it is a self-defense. You don't have the time to go to the police and seek for protection. It's a midnight. Yeah, robbers or dacoities entered into the house. Midnight, robbery, dacoity, etc. So you can protect, self-protect. So that chapter is called as general exceptions. Of course, all these main aspects are continued in the BNS also. They have not been taken away. Certain new aspects have been given. Certain old offenses which are not required to the were deleted. We will come to that aspect. So I want to tell you only in the context of Indian Penal Code, we were in the stage of Indian Penal Code. There were 511 sections, 23 chapters. Each chapter dealt with a different type of punishment for different type of offenses. So it continued from 1862 to till 2024. If you are practicing advocate and particularly a criminal side, you are well familiar with all these offenses, etc. Even for law students also, because it is an important criminal enactment, you might have been discussed in your law colleges. What is Indian Penal Code? What is a definition of ingredients of an offense? Kinda cheptaru me lecturers. Ingredients. What are the particular ingredients as per the definition of that offense? Cheating కే ingredient ఉండాలి. అలాగే dishonest what is dishonest intention, what is that ingredient? So ingredient wise గా మీకు చెప్పుకుంటూ వెళ్ళి ఉంటారు. So this was the enactment which continued up to 2020. Continuing. Now coming to the new act. New act had seeds in the year 2000. The Indian government thought it fit that already Indian Penal Code came into force in 1862. Almost more than a century has passed. Since then, time has changed. So many conditions have changed. Most importantly, scientific advancement also came into, isn't it? Scientific advancement made the crime very standard and conventional crimes are converted into scientific crimes. ఇప్పుడు ఎవడో వచ్చి మన జేబులో తీసుకోడు, మనకు ఒక మెసేజ్ పంపిస్తాడు, ఆ మెసేజ్ మనం ఓపెన్ చేసి మన బ్యాంకులో జేబులో ఖాళీ అయిపోయినట్టు మన బ్యాంక్. దిస్ ఇస్ ఆర్ సైబర్ క్రైమ్ స్టేజ్లో ఉన్నాం మనం. రీసెంట్లీ ఇండియా పాకిస్తాన్ వార్ అని అనకూడదు, కానీ ఆ టైప్ ఆఫ్ మిలిటరీ ఆపరేషన్స్, నాట్ ది సోల్జర్స్ గోయింగ్ ఇన్ టు ఇన్ ఓల్డ్ సినిమా టైప్ గోయింగ్ అండ్ ఫాట్. They send drones. We have put up a S-400 protective Sudarshan Chakra type, they called it, and the drones were smashed in the air by the Indian military. It's all like a cyber game we fought like. Our missile system very with precision went and struck to the hideouts of the terrorists in their country. Not our people have gone. Of course, one or two fighter jets fighting along with the jet, that pilots might have gone, but most of the fighting or war went with a all in a scientific mode. So in offenses also, by 2000, because internet was introduced way back in other countries 70s నుంచి కూడా ఉంది, మన కంట్రీకి వచ్చేసరికి 90s లోకి వచ్చేసింది. That is why in 2000 crime started by using the internet and computers. So 2000 we have already introduced IT Act, isn't it? Information and Technology Act defines certain offenses, is not it? Source code tampering, then sending obscene material into others' computers, etc. By that time, cell phones also introduced. So world has changed drastically since 1862 to 2000. Already we have introduced the IT Act. So the Indian government felt that our Indian Penal Code should be revisited, that means reviewed, to study and give our suggestion what more changes are required in the Indian Penal Code. Understood? Every time, because law is ఒకటి గుర్తుపెట్టుకోవాలి మీరందరూ కూడా, law is not a static one. Law is a dynamic one. Dynamic means in our legal parlance చెప్తారు మనకి. Law is a dynamic one means law changes with the requirements in the society. With the change in the society, law also need to be changed. For example, till 1988, the giving of money, taking of money by mostly by way of pronouns or bank checks, bank drafts, etc. If the check is dishonored, you have to file a civil suit only. This civil suit used to take 10 years or 20 years. The object of business and the commerce was delayed. So they introduced, what is it? NI Act. NI Act covering the checks, definition of check and pronouns, etc. Wanted to introduce the new sections to the existing NI Act, making dishonor of the check as a penal offense. 138 to 143 were introduced, isn't it? Because society required a change in the law. Therefore, a new enactment was brought into, an amendment was brought into NI Act with amendment of 138 to 143 were introduced to section NI Act. If a person gives a check to other for due discharge of legally enforceable debt, only for the purpose of debt, gift check ki panikiradu. A check was given, that check was dishonored by the bank, then it is an offense. Of course, you have to give notice to pay back that amount. If he still has not paid, you can take a punishment, you can file a criminal complaint in a magistrate's court. So this is a change in the law. In our days, it was not there. 1985, I came into the practice. At that time, it was not there. 1988, it was introduced. 1989, another law was introduced, because the youth, because of the country was spoiled because of the use of the narcotic and psychotropic substances. అప్పటికే ఉంది ఈ గంజాయి, నల్ల మందు అమ్మి యువతని నిర్వీర్యం చేయడం, అటువంటివన్నీ. To tackle with it very strongly, at that time there were no strong laws. NDPS Act was introduced, is not it? Narcotic Drugs and Psychotropic Substance Act was introduced. So, with the requirement in the society, a new law will come, has to come to protect the society. That is why it is called as law is a dynamic one, but not a static one. It has to change. It has to change to suit the requirement of the country. So Indian government in 2000 felt that Indian Penal Code, whether it is serving the purpose or anything new things have to be introduced or not, they appointed a committee called as Justice Malimath Committee. Is not it? You can write it Justice Malimath to make criminal reforms, to make the criminal justice system reforms. Justice V.S. Malimath was the Chief Justice of Karnataka. He was appointed along with some committee members to study the Indian Penal Code and other laws to suggest the amendments. That is how that committee worked for 2-3 years and submitted a report in 2003. Justice Malimath, MALIMATH, నెట్లో కొడితే మీకు కూడా ఇది వస్తుంది, మెటీరియల్ తెలుస్తుంది అన్నమాట. So this committee studied. They felt that Indian Penal Code, in certain aspects, it requires improvement, amendment. What are those 5 or 6 points? I will tell you. Please understand. That is the source, or that is the seeds have laid down by that committee in 2003. One is a review of reenactment of IPC. The substance of the report is a review of Indian Penal Code, the review of Indian Evidence Act, and criminal procedure is essential. They felt it. Why so? They have given it. One of the points they stated is they felt that punishments for major offences grossly inadequate. You have provided punishment for a particular offense depending upon the situations prevailing in 1860, but now the population increased, offenses have increased, the modus operandi is increased. For a small, you are also sometimes teasing, ghastly offenses are committed for small amount. Chain snatching, if anybody resisted, they used to they don't bother to kill them also. So such a drastic offenses have been perpetrated by the criminals. In those days, you have prescribed the offenses, very minute offenses for certain type of offenses. You have to provide, therefore the requirement is there to amend the punishments. You have to provide more stringent punishments. That is one cause for amendment to the IPC. Another is life imprisonment. Life imprisonment is there, isn't it? 302, either death or life imprisonment can be given under 302. Life imprisonment, if it is provided, there is a remission provision is also there in remission, section 362 or 63 in CRPC. If he served for 14 years in jail, the government may take his conduct in the jail and may recommend for his expiation. That means for review him and send him home to him if his conduct was good for 14 years after punishment. This committee felt that under that guise, so many people on political grounds etc. were given the what you call a type of concession to them. So, but sometimes we need life means life, till the end of the life punishment should be there. One of the recommendations they have given. So there should not be any concession. That is what they felt it. For that, Indian Procedure Code need to be amended. This is one of the view expressed. Of course, it is the views expressed by the Malimath Committee. Then, most important suggestion is, in Indian Penal Code and Criminal Procedure, only 4 types of punishments are there. One is death penalty. Then life imprisonment. Imprisonment for a particular years, 10 years, 12 years, 8 years, 7 years, 6 years, whatever be the length of the time prescribed under the Indian Penal Code, that is there. So death penalty is there, life imprisonment is there, imprisonment for a number of years are there, then fine is there. These type of punishments are only there. There should be another type of punishment also. It should not be strictly called as punishment, but it loose sense it can be called as punishment. That is, community service should also be introduced. It was prevailing in the Western countries. Community service ante in jail కూర్చోబెట్టకుండానో ఫైన్ వెళ్ళి కమ్యూనిటీకి సేవ చేయి, హాస్పిటల్లో 1 month ఆర్ పార్క్లో సర్వ్ చేయి, తుడు, ఆర్ మున్సిపాలిటీలో వర్క్ చేయి, సమ్ అదర్ పబ్లిక్ ఇన్స్టిట్యూషన్, లైబ్రరీలో ఉండు, లైబ్రరీనిగా పనిచేయి, లేకపోతే కలెక్టరేట్లో ఉంటాడు, కలెక్టరేట్లో వచ్చిన వాళ్ళందరికీ మంచినీళ్ళు కూడా తర్వాత వాళ్ళందరికీ దారి చూపించి ఏ విభాగం. సో యూ వర్క్ ఫర్ ది కమ్యూనిటీ యాజ్ అ మెజర్ ఆఫ్ పనిష్మెంట్. That is not there in Indian Penal Code. Indian Penal Code only is having death or life or conviction for so many years or at best fine. So Malimath committee wanted to introduce or recommended to introduce the community service also. This is one of the recommendations. Then most importantly, they wanted that certain very, very grave offenses, at that time only special enactments were only there. TADA Act, Terrorist and Disruptive Forces Act, TADA Act, UPA Act, Unlawful Possession of Arms Act, isn't it? UPA Act. So these are all special enactments. By nature of that laws, only some period they will operate. After that, the law will be closed. It is not an eternal law like Indian Penal Code, etc. They are called as, in legal parlance, they are called sunset laws. Sunset, sun will come morning and set in the evening. He will not be there in the night. If he is there, we can't call him as a night, isn't it? So they are called as, in the legal parlance, they are called as sunset laws. So Malimath committee stated that there are special enactments like TADA Act, UPA Act, etc. Their lifetime is only for a specific period. After that, they will extinct. If thereafter similar type of offense is committed, under what law they should be punished? This is a question. Therefore, they wanted that, they have recommended that the essence of the offense in those sunset laws be introduced in the Indian Penal Code and make them a permanent law. Indian Penal Code is a general law, isn't it? Till then, possession of a AK-47 rifle is not an offense prescribed under Indian Penal Code. TADA offense, terrorist activities, disruption of country, causing sovereignty, integrity of the country by terrorist activities is not an offense prescribed under Indian Penal Code. It is under the TADA Act. TADA Act has no permanent life. It was made for certain years. It extended for another time. Thereafter, there was no extension. If that is the case, after the extinction of that offense, after that extinction of that enactment, if any person committed an offense, what to do? So introduced similar type of offenses in the Indian Penal Code also. That is one recommendation made by the committee. So they wanted that offenses punishment should be amended, grievous strict punishment should be provided. Second amendment is, for certain of sending them to the jail or fine, you send them to the public places to do the community services, hospitals or public places like collectorate or courts, they will work. So this is another amendment they sought for. Sunset laws, the substance of sunset law offenses should be introduced in the Indian Penal Code itself, so that there will be a permanent offense. This is another type of this one. The fourth one is, okay, you have prescribed Indian Penal Code prescribed punishment by way of fine also, either punishment by term or fine, some offences. That fine is very minute, fine of 50 rupees, 100 rupees, because 1860, 100 rupees is a very, very valuable one. Now we are in 2000, by the time of Malamat Committee, the rupee value is very much diminished. So increase the fine amount. That is another amendment they sought for. And they have recommended for. Because the rupee value is decreased, the fine value may be increased in the offences. This is another what you call uh, amendment sought. Another most important amendment they have requested to the government is, look, certain offences are with a punishment of a term. ఏముంటుందో ఒక దానికి కొన్నిటికి మినిమం పనిష్మెంట్ ప్రిస్క్రైబ్ చేశారు. ఇఫ్ ఇట్ ఈస్ ఎ థెఫ్ట్, ఓన్లీ ఎగ్జాంపుల్, సబ్జెక్ట్ టు కరెక్ట్ ఇన్ ద టెక్స్ట్ బుక్ మీరు చూసుకోండి. సపోజ్ థెఫ్ట్ ఈస్ 3 years. 3 years means minimum 3 years. For that there is no problem. Certain offences he can be punished up to 12 years, for example, up to 10 years, up to 7 years, up to 5 years. This up to means starting from 1 day to 5 years, any length of prescription is can be a legal punishment. But up to means what is the proportionate punishment is awarded. There is no prescription, there is no guideline. Are you able to understand? Certain types of punishments, director may assist me by seeing the Indian Penal Code, give me some example for better appreciation of our students. Certain type of offences are minimum punishment is not provided, only maximum punishment. He can be punished up to 7 years. He can be punished up to 3 years for this offense. He can be punished up to 6 years. Up to ఏదైనా లీగల్ పనిష్మెంటే. బట్ జడ్జ్ యూ ఇట్, ఓకే ఐఎమ్ పుట్టింగ్ యూ 5 years. ఏంటి ఆ స్టాండర్డ్, కొలమానం ఏమిటి దానికి? దేర్ ఇస్ నో గైడ్లైన్స్ ఇన్ ది లా. ఐపీసీలో ఉందా? అప్ టు 5 years అనే ఉంది, అప్ టు 6 years, అప్ టు 7 years అని మాత్రమే ఉంది. బట్ దెర్ ఇస్ నో ప్రిస్క్రిప్షన్ యాజ్ టు up to means, suppose I want to put only 3 years. Whether this 3 years is equivalent to proportionate punishment or not, there are no guidelines. So what they recommended is there should be some guidelines. See, for an offense up to 7 years is there, but if you want to punish him only up to 1 year, the offense must have been committed with this type of offense must have been committed. Broad offense is, for example, theft. If he committed a theft of 1 lakh rupees or 1 rupee, offense is 3 years only. There is no distinction. So they wanted, perhaps they wanted up to 10,000 rupees if he committed theft. If he increases, the length of punishment should also be increased. There is no guideline to that effect. Understood? So they wanted to give a recommendation to the government that this outer punishment is only prescribed, but there are no guidelines to the courts, judges, to arrive at a corrective punishment. So let the guidelines be given. This is what the report they have submitted in 2003. Isn't it? Not immediately the BANS has come. After 2003, there was some gap. Then again they appointed, because the gap is there, they appointed another committee to study. That is Justice Dr. Ranbir Singh. Dr. Ranbir Singh was the Vice Chancellor of Delhi National Nehru Law the NLU, National Law University, isn't it? Delhi was appointed, and that committee submitted its report to amend the both Indian Penal Code, Criminal Procedure Code, as well as Indian Evidence Act. They have given the recommendation. They have taken Malamat committee's recommendations also. They added some more recommendations, and they submitted the report to it. Basing on it, these three enactments were brought into force. Is not it? So, of these three enactments, which came into force with effect from 1/7/2024, now we are concerned with what is that? We are concerned with mainly Indian Penal Code equivalent. Any punishment for any offense?
307 attempt to murder.
Attempt to murder is up to life is there, or
Which may extend to 10 years and shall also be fined if the hurt is caused to any person by such act. The offence shall be either to imprisonment for life or to punish such punishment as is hereinbefore mentioned.
so first is 7 years, isn't it?
Yes, sir. 10 years, sir.
10 years. Shall be punished with imprisonment of either description for which may extend to 10 years and shall also be fined, and it may hurt is caused to any person by such act. So attempt to commit murder is attempt is made by causing hurt or without causing hurt also sometimes, isn't it? He has what you call shot the gun, but providentially he escaped it. It did not hurt him, but he made an attempt to commit murder. So he will be booked for 307. What the law says is that if a person has committed an offense of attempt to commit murder, he has to be punished with an offense punishment up to 10 years. But in the course he caused also hurt, he may be punished with life also. So take an example. He made an attempt. Suppose he wielded a knife or a sword. Luckily, that man escaped. It did not fall on his neck, but he escaped and it fall on some other object, so he saved. But attempt was made. Had he not escaped, his head would have been chopped. So the law takes that attempt as an attempt to commit murder. In the first case, if he has no hurt is caused, he will be punished. He can be punished up to 10 years. This up to is causing some problem. Up to means 1 day or 10 years. What is the correct punishment? Up to only the law says. So the Malibath committee felt that there must be some guideline to the judge. What is the nature of offense use? What is the force used? Depending upon it, 1 year or 2 year or 3 year or 4 year or up to 10 years, there must be some guideline. That is what the recommendation made. Now you understood what the opinion or view of the Malibath committee felt. There must be guideline to fix a proper punishment for an offense, nature of the offense. Now come to this one, our BNS. We have now reached the BNS. This Ranbir Singh committee studied it again, had taken the recommendations made by Malibath. They have added one or two. First, most important is sedition law. మీ అందరూ వినే ఉంటారు రామచంద్ర పెద్ద అప్రోర్. సెడిషన్ మీన్స్ ప్రభుత్వాన్ని కూలదోసేటువంటి చర్యలు. సెక్షన్ 124 ఐపీసీ వాజ్ సెడిషన్, దేశ విద్రోహం అని అంటారు. 124 they felt that it was during the British government prevailing Indian patriots like Balagangadhar Tilak or some other patriots, they wanted to make agitations in order to put them in jail, that section 124 was introduced. Is in the present day context that is not required. 124 may be taken away from the statute book. That is one of the views. Even Supreme Court also, in a given judgment, they stated that you, the central government, study on it and take a decision on it, was the Supreme Court's view expressed. So this Ranbir Singh committee has felt that this 124 Indian Penal Code should be 124 capital A should be taken away from the statute books. This is one of the recommendations. Then they wanted to introduce some more offences. In the recent years, in the recent decades, this what you call honor killings. Honor killings means by nature the youth are falling in love, one caste person, religion person, another religion person, they are trying to marry, but one part is relations. They don't want. They in a group. They are the honor killings you are hearing on papers and YouTube, etc. Isn't it? So this is a mob lynching. Mob lynching means in a group for a particular purpose, not for money or something, but to under the false prestige of the family or some other ego problem, they are making this group offense, a group of five or more, for a particular purpose of saving the honor of the family. They are doing this type of, మీరు కూడా పేపర్లో వాటిలో చూస్తున్నారు కదా అప్పుడప్పుడు వచ్చేవి. సో టు మీట్ దట్ టైప్ ఆఫ్ అఫెన్సెస్ దే హ్యావ్ రికమెండెడ్ దట్ సమ్ మాబ్ లించింగ్. లించింగ్ మీన్స్ గ్రూపుగా సమూహికంగా ఒకరిని హింసించేది లేకపోతే కిల్ చేయడం, హర్ట్ చేయడం, దాన్ని ఇంట్రడ్యూస్ చేయమని this Ranbir Singh committee has recommended mob lynching. The offence was introduced. Of course, we will come to that offence. So, taking the, they also requested for this communal service, community service punishment also. Let it be introduced. That is also one of the recommendations made by the Ranbir Singh. So, taking all these recommendations from one set from the Malamith committee in 2003, recently in 2012 or so, 11, I think they have appointed, and in 2012 they have given the committee to the parliament. They studied it and they have introduced the three new enactments. These three new enactments are called as, we have discussed, BNS, BNSS, and for short BSA, with effect from 1/7/2024. This is how these three enactments have come with some new sections. Some sections were repealed, etc. Let us come to mainly discuss the important facets. We will have a thumbnail sketch of BNS, Bharatiya Nyaya Samhita. This is having, unlike the Indian Penal Code, it is having only 358 sections. That Indian Penal Code was having 511. See the vast gap between these two. This is only 358 sections. That is having 511 sections. That 511 sections in 23 chapters. This is having only in 20 chapters. The difference is with 358 sections. That is 511 sections with 23. You may put me a question. So around 150 sections were taken away from the book. No, not like that. Not like that. Not all sections were taken. Just note down how they arranged. What is the method adopted is, in Indian Penal Code, for every aspect a new section was introduced. That is why 511 sections. Even definition chapter, if you take explanation, section 5 to 53, every definition is an independent section. But what they did in BNS is, all definitions is only one section and subsection A, B, C, D. Therefore, 50 sections are concised into one or two sections. That is how 50 sections are concised at a kudincher. But some sections were deleted from the statute book, I will tell. So, how 511 sections are converted into 358 is, first principle is, in chapter 2, general explanation in IPC, section 6 to 52A, each aspect was given an independent section. That is taken away. Section 3 and section 2 and section 3 are only main sections. All other aspects are subsections A, B, C, D, E, like that. That was one change. Then in Indian Penal Code, main offense will be only one. Its different aspects are given independent sections. Suppose stolen property. ఒకడు దొంగతనం చేస్తాడు. He commits an offense of theft. వాడు ఉంచుకోడు కదా, బంగారం అయితే దొంగలడితే ఏం చేస్తాడు, ఏ షాప్కి తీసుకెళ్ళి అమ్ముతాడు. ఆ దొంగ బంగారాన్ని తెలిసి కొంటే you are a recipient of the stolen property. This is also an offense. 411 is an offense. So theft is one offense, but retention by different persons are given independent sections in the Indian Penal Code. But what they have done, BNS, all these different types, subgroups are included in the main section by way of A, B, C, D, E. For example, in Indian Penal Code, section 410 to 414, stolen property is the main aspect, but under different circumstances is under 411, 412, 413, 414, etc. there. BNS లో ఏం చేశారంటే these are all concised into one section 370. సో అక్కడ 5 sections తగ్గిపోయినాయి కదా. This is how 511 sections are concised into 358 for easy reference understanding. Certain offences are deleted. Certain offences, for example, 377, unnatural offence, that is taken away because Supreme Court has given it is against the interest of LGBTs, that is transgender's interest against the కాబట్టి 377 was deleted. Section 497, adultery, no more adultery in its form is not an offence now, because 497 can only be a ground for divorce. Supreme Court judgment, you might have read it, isn't it? Because the Supreme Court felt that it is against the interest of a woman. Though woman is not punished under 497, but still they felt that is violation of Article 14, 15 and 16. Their right to choose a partner left it to the woman. You are intruding into the matrimonial affairs. If the husband is felt annoyed, he can resort to the civil court for divorce, but it cannot make it a criminal offense. That is what in those lines that judgment went on. Therefore, 497 was also taken away from the book. Similarly, some trademarks violation, because trademark violation that is there, they felt it is not necessary in that form. So 478 is also taken away. 377, 497, then 478, 480 also. Using false trademark and doing business is also an offense because it is covered under Trademarks Act. Intellectual property rights for trademarks, patents and designs covered under that one. No need of making it a specific offense under the Indian Penal Code. So they have taken it away from the BNS. So 377, 497, 478 and 480 are taken away from the BNS. Then punishments I have already dealt with you. In the different types of punishments, one more extra punishment is prescribed is community services. This is how in those aspects the BNS is newly reset or reviewed and reintroduced. Old Indian Penal Code with the 17/2024, it has been repealed. But though it is repealed under section 6 of the General Clauses Act, it will continue for the offences committed prior to 17/2000. That you must know it. The Indian Penal Code will operate for the offences committed prior to 17/2000. 30th June 2024, if an offence is committed, you have to deal with BNS. BNS ఎప్పటి నుంచి అంటే అర్ధరాత్రి దాటిన తర్వాత 1/7/2024 was entered into with the midnight of 30th June 2024. So this enactment is not having prospective, it is having only prospective operation, not retrospective. Understand? Why so? You have to again study Indian Constitution, Article 12, 13, etc. There is no ex post facto criminal laws. Retrospectivity to penal laws ni cheyaru eppudu general ga. In a very very rare case, only prospective they will be dealt with. If you want to study Article 12, 13, etc. Indian Penal Code. What do you mean by ex posto? EXPOST, posto. Constitution చదివేటప్పుడు మీకు చెప్పి ఉంటారు, but for your gaining knowledge, further improving knowledge, you please study Article 12 and 13, etc. What do you mean by ex post facto criminal law? Criminal laws generally will not be introduced with a post. Suppose yesterday smoking in a public place is not an offense. A person had a smoked in the public road. It was not an offense. Today an enactment was brought saying that smoking in public places is an offense and it is an offense from yesterday. నిన్న ఏది అఫెన్స్ కాదో ఒక యాక్ట్ ఇవాళ చేసిన చట్టంతో నిన్నటి చర్యని పనిష్మెంట్ చేయరు. ఆయనకి నిన్న అఫెన్స్ కాదు కాబట్టి ఐఎమ్ గివింగ్ ఎన్ ఎగ్జాంపుల్. He smoked in the public place because it was not an offense. You cannot make a criminal law making a particular act as an offense with effect from a previous day because you are taking the life and liberty of a person. Understand? You are taking by that punishment. What is the punishment? Suppose in a public place a cigarette smoking is visited with a punishment of 1 month imprisonment and 1,000 fine, let us say. He has to undergo punishment for that act, but yesterday it was not an offense. Therefore, generally, no penal law will be made with a retrospective operation. That is called as ex posto. Posto means path date. Ex post facto criminal laws. Civil laws. Civil law can be made with the operation of backdate. If the law specifically tells that it operates with backdate, or by a judgment, the Supreme Court or High Court, by nature of that law, they can say that yes, it has got retrospective operation also. It may tell. Today, for example, a very important judgment has come, which has a bearing for you, whether the candidates must have 3 years an examination for junior civil judge. That was reserved in January. And in the meanwhile, so many notifications have come, and without necessity of 3 years practice, and students are appearing because they passed the law, they attempted. But today's judgment is what? The Supreme Court made it clear that no, you must need to have 3 years experience to take the examination. But they carefully mentioned that this judgment of ours applies to onwards. It will not affect on the notifications issued by the high courts till today. సో ఇప్పుడు మీరు ఎవరైనా కూడా జూనియర్ సివిల్ జడ్జ్ ఎగ్జామ్కి ఆల్రెడీ అపీర్ అయ్యి ఉంటే, ఆ ఎగ్జామ్ తీసుకోవడానికి నోటిఫికేషన్ ప్రకారం అప్లై చేసి ఉంటే, though you didn't have 3 years experience, your candidature can be accepted. This judgment is only a prospective operation. Understand? Is not having retrospective operation. So that is how operations will be either prospective or retrospective. But criminal laws are concerned, take it for granted, 99% cases, a criminal law enacted by parliament or state will be having generally prospective operation. This particular BNS is also having only prospective, not retrospective. So any offense committed on 30th June, the last day of its operation, that is 30th June 2024, if any person committed an act which is an offense under Indian Penal Code, the police and courts apply and look into the Indian Penal Code, not the BNS. But 1/7/2024 onward, you have to look for this enactment, that is BNS. This is made clear in section 358. Okay, for your comprehension, I am telling. So these are the main aspects. This law is having 358 sections, 20 chapters, new enactments, new aspects brought in the matter of punishment. Punishment is by way of introducing what you call a community service for certain type of offenses. I will tell you quickly within 5 minutes what are those offenses. Then mob lynching is a new offense introduced. Then the sedition 124A was taken away from statute, but was introduced in the form of 154 with a slight difference. The essence of 124A was introduced in section 154, that is there. Sedition is taken away from the statute books. Because sensational one is introduction of the community services, what are the offenses for which community service is provided? That you please note down. 5, there are 6 offenses for which community service is provided in the BNS. First offense is 202, section 202. You just write down the sections. I will tell you what are section 202, BNS, not IPS. Now we have reached to the BNS. Section 202, 209, 226, 303, subsection 2, 303, subsection 2, 355, and 356. These are the 6 offenses for which understood, all of you? For the 6 sections, this community service as a measure of punishment was introduced. First one is 202, second one is 209, third one is 226, fourth one is 303(2), then 355 and 356. What are those offenses we look into? First is 202. What is this section 202? A public servant unlawfully engaged in a trade. See, service laws, according to service law, if a person is in a public service, suppose he is a clerk in a Tahsildar office or collectorate or electricity office or some other government service, he should not engage himself in a trade or and a business lo undakodu. Why? Because he may utilize his office for promotion of his trade in commerce. Is not it? Give an example. If a collector is parallelly doing a business, it's only an example I'm giving. A collector is district collector is engaged in, he opened a shop. Can't he use the influence of his office for promotion of his what you call business? This is something very odd. He should not use it. It should not be allowed. So public servants should do only public jobs, not private business. If they do it without the knowledge found to be doing it, it is an offense. For that offense, what are the punishments prescribed is, he shall be punished with simple imprisonment for a term which may extend to 1 year, or with fine, or with both, or with community service. Here the community service is one type of punishments provided to him. Okay. Next, 209. 209 is again violation of the public order. Okay. That is, suppose summons and that person do not appear without any reason. Non-appearance to a proclamation. Summons, next stage is proclamation. Suppose in criminal cases, what will happen is, or for that matter in civil cases also, but mainly in criminal cases, an accused is there. A summon is issued to appear before the court and face the trial. He do not appear. He doesn't appear. The court will 2 or 3 times will do it. Then the police will return the summons. He has absconded, sir. You write them. Then the court will declare him as a proclaimed offender. Proclaimed means the court will proclaim that this man has run away from the jurisdiction of the court. He is not attending. Proclaimed offender కింద పాత దాంట్లో అయితే సిఆర్పిసిలో సెక్షన్ 83, 84, 82 ప్రొసీజర్ ఉండేది. The court will declare him as a proclaimed offender and direct the public authorities like a collector and all this to seize his assets, if any, and sell it in a public auction and deposit as a measure of threat, coercion. ఆయన ఆస్తులన్నీ అమ్మేసి ఆ అమ్మేసిన ఆస్తులన్నీ గవర్నమెంట్ ఖజానాకి జమ కట్టమని ఒక ఆర్డర్ ఉంది. దట్ ఈస్ వాట్ ది proclaimed offender. Besides, running away from the jurisdiction is a criminal offense also. It is another offense for which the punishment is provided in section 209. Whoever fails to appear at the specified place in specified time as required by proclamation published under section 1 of section 84 of Bharatiya Nagarik Suraksha Samhita shall be punished with imprisonment for a term which may extend to 3 years, or with fine, or with both, or with community service. Again, so disobedience to the court orders in a manner, isn't it? It's a disobedience to the court order. Court you face the trial, engage a lawyer, prove yourself is innocent. You do not appear into the court in spite of repeated summons, issuing proclamation also you are not. Sometime thereafter, police caught him and brought before the court. But violating the court order itself is another offense. Main offense is something. This is an additional offense for which the punishment is prescribed, among other things, the what you call community service. So 209 law ఒకసారి. Then 226. This 226 is it is threatening the public servants in different manner. 226, an attempt to commit suicide. An attempt to commit suicide to compel or restrain exercise of the lawful power. A public authority is there. Public authority has to dispose of its duties, public duties, to threatening that public officer to do in a particular manner or not to do in a particular manner. You are threatening him not to beat him or so. I will commit suicide if you do not do it. చాలాసార్లు మనం చూస్తుంటాం పేపర్లో వీడేమో పెద్ద టవర్ మీదకి ఎక్కిపోతాడు, మాకు అప్పులు రుణాలన్నీ మాఫీ చేయించండి, లేకపోతే నాకు 5 ఎకరాల పొలం ఇవ్వండి, నేను భూమిలో నిరుపేదని, లేకపోతే ఎలక్ట్రిక్ వైర్ పట్టుకొని వచ్చి ఆత్మహత్య చేసుకు. So this type of threatening the public servant to do his discharge his duties in a particular manner or not to discharge his duties is also a type of, it's causing any amount of annoyance to the public servants, isn't it? If you threaten like that, how they will discharge their duties? This is an offense for which also the punishment is extended to 1 year or with fine or with both or with community service. In community service is made a one such punishments. Next, 226 thereafter, 303. This is important. We may come in regular practice. This is more important one. 303 says that it is akin to 379. Theft. Theft in Indian Penal Code is equivalent to 303. 303 what it is? ఉండేదో theft, equivalent section is 303 theft. Theft, you know, various types of theft it has given. 303 subsection 2 says that this is important. Whoever commits the theft shall be punished with imprisonment of either description for a term which may extend to 3 years or with fine. Generally for theft punishment is 3 years. అయితే ఇక్కడ ఏముందంటే provided that in case of theft where the value of the stolen property is less than 5,000 rupees, this is more important. Understand? If a theft is committed, that value of that property, chain or ring or cash has committed theft is less than 5,000 rupees, punishment is what? And a person is convicted for the first time. So first time he has committed less than 5,000 rupees or worth 5,000 rupees. He shall, upon return of the value, again he paid back after trial or so, then he shall be punished with community service. So community service for a theft offender, when it must be a first offense, is only ప్రథమ నేరం కింద చేశారు. ఒకసారి పేపర్లో కూడా ప్రథమ నేరం అంటే ఫస్ట్ టైం has committed. Value is 5,000 or less than 5,000, maybe gold or silver or article, whatever it be. Only value is 5,000 or less. During trial or during inquiry or during investigation, he given back that property. In such a case, because offense is offense, in such a case, taking all these facts into consideration, the court may award him the community service. Okay, so this community service is prescribed for theft offense provided value is less than 5,000. Then comes what is another offense for which community service, section 355. 355 is misconduct in a drunken stage. Drunk and drive cases ఒకసారి మనం చూస్తుంటాం, or drunk and bad behavior in a public place. For that also Fine is simple imprisonment of 24 hours or fine up to 1,000 or with both or with community service. Here also community service is one mode of punishment, 355. Then 356, defamation. Old law, defamation is 499 definition, 500 is the offending section, 500. Old Indian Penal Code. Now under the BNS, 356 is a defamation. Defamation also punishment is 2 years or with fine or with both or with community service. Here for defamation also, one of the modes of punishment is the community service. So now all of you understood what are the different types of offenses for which community service is one mode of punishment: 202, 209, 226, 302, 303, 355, and 356. These are the 6 sections in which only community service is provided. Yes, please. Oh, please. ఇక్కడ ఒక చిన్న you madam, you come, we'll discuss a small aspect. I have to discuss with the community service. Sometimes a problem may come. That is what important in dealing with the community service. Suppose a community service is provided as a punishment. Suppose he did not oblige. నువ్వు వెళ్ళి 1 month లైబ్రరీలో లైబ్రరీగా పనిచేసి పుస్తకాలు దొరికి వచ్చిన వాళ్ళందరికీ ఇస్తూ ఉండాలి. ఓకే, he doesn't do it. What is the next? Suppose a fine is imposed. Fine if he does not pay 424 etc. To realize the fine amount, the court can take steps to attach his properties and recover it is one, or send him to the jail for that proportionate 1,000 rupees worth అయితే 6 months worth punishment. Okay, but so far as the community service is concerned, it is provided to him as a measure of punishment. He did not oblige it. He did not do it. What is the next step for him? That is not provided in this enactment. You study yourself. Have any, suppose I have the magistrate imposed 1 month per 6 sections ఉన్నాయి కదా, 5,000 rupees కంటే తక్కువే ఉంది ఏది theft property. He has committed, this is the first offense, he paid that amount, he paid I see the very crucial aspect in the community, because the first time it is provided by law, you must carefully understand its nuances, principles. Community service as a measure of punishment will pose 2 problems to my, at least you study deeply. First one is, what do you mean by community service? Is there any definition in the BNS? You don't have the definition. మీకు ఎక్కడ డెఫినేషన్ ఇవ్వలేదు, బిఎన్ఎస్లో ఎక్కడ డెఫినేషన్ లేదు. వాట్ యూ మీన్ బై కమ్యూనిటీ సర్వీస్? నువ్వు వెళ్ళి మురుక్కాలు తులువు, ఇట్ ఈస్ ఎ మీన్ సర్వీస్. కమ్యూనిటీ సర్వీసే కాలువలు తుడువు, డ్రైనేజ్ సివరేజ్లో అడుగుకి వెళ్ళి తుడువు అన్నారు అనుకోండి, community service. Whether such type of punishment can be given. Understand? You go to like Sulabha people, I mean, with the due respect to them, in RTC bus stops or railway stations, you clean the toilets. It is a community service, no doubt. But can such type of punishments be awarded? It is also a community service. Engage him and you clean the garden, public park undi, meeku Uda park or Tuda park edo undi clean cheyamanar. Okay. You stand before the hospital, general hospital, you serve like a nurse. Okay. It is a community service, dignified community service, and certain persons, certain community services are mean. వాళ్ళకి బతుకు లేక వాళ్ళు చేస్తుంది. I am throwing open because you must think yourself. I am not providing any answer. I don't have also. Community service is not defined in the BNS. First thing, it's not defined. Community service, if he has not done what is the equivalent punishment you should provide by way of paying fine or by way of putting him into jail is all. There is no equivalency. It is not given. So you must carefully study it. అయితే కమ్యూనిటీ సర్వీస్ ఎక్కడుంది? ఈజ్ దెర్ ఎనీ డెఫినేషన్? బిఎన్ఎస్లో లేదు. You have to, if you happen to read laws, etc., if you study in Juvenile Justice Care and Protection Act, Juvenile Justice Care and Protection Act లో రూల్స్లో ఎక్కడ ఉంటుంది అంటే రూల్స్ 2(6) సబ్ రూల్ 6లో మోడల్ రూల్స్ 2016లో ఉంటుంది. జువెనైల్ జస్టిస్ కేర్ అండ్ ప్రొటెక్షన్ మోడల్ రూల్స్. అక్కడ కూడా జువెనైల్స్ అంటే ఎవరు? వాళ్ళు చిల్డ్రన్. జువెనైల్ మీన్స్ నాట్ ఎక్సీడింగ్ ది ఏజ్ ఆఫ్ 18 years, isn't it? Not completed the age of, like a minor అనమాట. If they are conflict with law, that means they have committed certain offense. మన అఫెన్స్ అనకూడదు ఆ లా పరిభాషలో. దాన్ని juvenile in conflict with law has committed certain act which was found to have committed, then as a measure of reformation to him, the court, juvenile court, may ask him to do community service out there. That is why community service is defined in that enactment. రేపు మిమ్మల్ని ఎవరైనా ఇంటర్వ్యూలో what do you mean by community service అంటే, understand, you have to carefully study. ఎక్కడైనా డిఫైన్ చేశారా? బిఎన్ఎస్లో లేదు, మెయిన్ ఎనాక్ట్మెంట్లో లేదు. బట్ ఇన్ ఎనదర్ మేనర్, in another context, in another law, it was defined. Understand? That is the Juvenile Justice JJ Act and Juvenile Justice Care and Protection Act 2016 rules law, Rule 2(6) law. We will see what is community service. Community service means service rendered by children in conflict with law who are above the age of 14 years. మళ్ళీ అందరికీ కమ్యూనిటీ సర్వీస్లో వేయకూడదు. 14 years మించి ఉండాలి వాడు. 14 years లోపు వాళ్ళు అయితే వాళ్ళని కరెక్షన్ హోమ్కి, స్పెషల్ హోమ్కి పంపించాలి, చదువుకోవడానికి మాత్రం పంపించాలి. 14 years దాటిన వాళ్ళు అయితే 18 years లోపల ఉంటే వాళ్ళు పనిష్మెంట్కి యాజ్ ఎ మెజర్ ఆఫ్ పనిష్మెంట్ అని మనం అనకూడదు. బట్ ఇన్ ఏ కామన్ ప్యారలెన్స్ ఆఫ్ టెల్లింగ్, దే ఫౌండ్ టు హ్యావ్ డన్ అన్ యాక్ట్ ఇన్ కాన్ఫ్లిక్ట్ విత్ లా అండ్ జువెనైల్ జస్టిస్ బోర్డ్ హెడెడ్ ఏ జువెనైల్ జస్టిస్ మ్యాజిస్ట్రేట్, దాని స్పెషల్ మ్యాజిస్ట్రేట్స్ ఉంటారు, అయితే జనరల్ మ్యాజిస్ట్రేట్స్నే దాని కింద డిజిగ్నేట్ చేస్తారు. మీరు చూసాం కదా కోర్టులో, ఇక్కడ తిరుపతిలో కూడా జువెనైల్ జస్టిస్ హోమ్ ఉంది. ఇక్కడ నేను వెళ్ళేవాడిని తిరుపతిలో పనిచేసేటప్పుడు. అండర్స్టూడ్? సో that magistrate imposes him a community service. What is that community? Nature of the community service includes activities like maintaining a park, సర్వింగ్ ది ఎల్డర్లీ. ఓల్డ్ ఏజ్ హోమ్కి వెళ్ళు, ఆ పెద్దవాళ్ళకి సేవ చేయి, స్నానం చేయించు, వాళ్ళ పక్కలు ఇది చేయి, వాళ్ళకి మందులు ఇయ్యు, వాళ్ళకి అన్నం పెట్టు. ఎవరైతే ఇది చేయలేరో, మీకు తిరుపతిలో కూడా ఓల్డ్ ఏజ్ హోమ్స్ ఉండి ఉంటాయి కదా, రికగ్నైజ్డ్ ఓల్డ్ ఏజ్ హోమ్స్, అక్కడికి పంపించండి, సేవ చేయమనండి. సో మెయింటెనెన్స్ ఆఫ్ పార్క్స్, సర్వింగ్ ది ఎల్డర్లీ పీపుల్, హాస్పిటల్కి వెళ్ళి నర్సింగ్ డ్యూటీస్ చేయడం, రోగుల్ని, కదలలేని వాళ్ళని, మొబిలైజ్ అవ్వలేని వాళ్ళని వీల్ చైర్లో పట్టుకెళ్ళడం. సో సర్వింగ్ ఇన్ ఏ హాస్పిటల్, సర్వింగ్ ఇన్ ఏ పార్క్, ఆర్ సర్వింగ్ ఎల్డర్లీ పీపుల్, ఆర్ ఇన్ ఏ నర్సింగ్ హోమ్. నర్సింగ్ హోమ్లో కూడా వాళ్ళని ఇది చేయొచ్చు. పెద్ద పెద్ద హాస్పిటల్లో చిన్న చిన్న ప్రైమరీ హెల్త్ సెంటర్స్ అవి ఉంటాయి కదా, డిస్ట్రిక్ట్ లెవెల్లోని, విలేజ్ లెవెల్లో, అక్కడికైనా పంపించవచ్చు. చేసి అక్కడ సర్వ్ చేయి, ఇన్ని రోజుల పాటు చేయి. ఆర్ సర్వింగ్ డిజేబుల్డ్ చిల్డ్రన్కి హోమ్ ఏదైనా ఉంటే వాళ్ళకి సర్వ్ చేయమని చెప్పడం. సో సర్వింగ్ ఇన్ ఎ పార్క్స్, పబ్లిక్ ప్లేస్, serving in to the elders, serving in a hospital, serving in a nursing homes, or serving to a disabled children, serving as a traffic volunteer, traffic constable పక్కన నిలబడి నువ్వు మ్యాన్ చేయి హాస్పిటల్, అది కూడా ఇవ్వచ్చు. రోడ్ రూల్స్ని ఇంప్లిమెంట్ చేయడంలో కూడా నువ్వు చేయవచ్చు. స్కౌట్ పిల్లలకి వాళ్ళకి ఇది చిన్నప్పుడు ఇది చేసేవారు. సో వాట్ ఐ మీన్ టు సే ఇస్, this what is community service is prescribed in the JJ Act, but not in your main enactment like BNS. But for the first time in 2024, I have given that is why I have given a list of 6 offenses. This 6 offenses, community service is there, but what is community service is not known. This is one problem. Problem means it is a issue. You have to think. Second one is when the offense is when that punishment is prescribed, that man do not serve, is not committed. What to do? In lieu of that, he should be again punished, isn't it? So what to do is main punishment only be given to him. Not a default punishment, but as a main punishment. Section K offense undo, offense can punish cheyalsi vastundi. So this is a bit of debatable issue. So far, no court, none of the high courts or Supreme Court has given clarity on this aspect. But you study yourself. If you can find in internet or something, it's well and good. But I'm throwing open a issue before you so far as community services are concerned. Then, what are the new? It is only offense. New punishment. New sections are open. Just 2 to 3 are there. Then we will close up. What are the new sections of or introduced is? First is section 48 is a new offense. Section 69 is a new offense. Section 95 is a new offense. And section 103 bracket 2 is a new offense. Section 106 is a new offense. Section 111 is a new offense. Section 100. Section 113 is also new offense. 226 is a new offense. Section 304 is a new offense. 304 is a new offense. Section 324 bracket 3 is a new offense. So how many? 11 offenses are new offenses which were not there in the Indian Penal Code for the first time introduced in the BNS. Just quickly look into them. After knowing it, we will close. These are what is section 48? Section 48 is a new offense is abetment outside India to commit offense in India. Abetment 109 was there, but not specifically abetment made from outside India because scientific advancement phone lo cheppochu abet cheyochu, isn't it? By way of internet, also sitting at the other end of the globe, you can abet a man in India to do this particular offense. So abetment is very, very easy nowadays. So the penal code, this BNS introduced a specific offense. You are abetting అంటే ఇంకోని ప్రేరేపించడం అంతే కదా. You do an offense అని. This man will sit anywhere outside the country. Abetment is done outside the country, but to inside the country is a specific offense now. It was not there before. So this is new offense. Understood? Then section 69. This is most important. As a lawyer, you must carefully understand this is a. I will tell you previous history. Previously, rape defined under what circumstances rape. One is against the consent of a woman. If you have committed a sexual intercourse, it is an offense. But there are some instances, most important type, vulnerable type is under the guise of love. I have loved you, we will marry you. These type of promises you make. Believing him, the girl consents for a sexual intercourse with that man. Thereafter, he left her without marriage. He has cheated her, isn't it? Then what is the punishment? It will not directly fall within the definition of rape because there is no question of not giving consent. Consent is there, but under the promise that he will marry, under the opinion that he will marry. So a man under the promise of marriage takes the consent of a woman and consents and having a sexual intercourse but do not marry her. What is this type of offense? Then because it is not a direct offense of rape under section 375, in those days in Indian Penal Code, What the courts used to do is, courts were taking the help of, it is no doubt consent was given. That consent is by misconception. You write down that word misconception. In those days also, the woman has given him the consent, but that consent is not a consent. You cannot take it as a consent under law because it was by misconception. Misconception అంటే by promise. She believed him by heart. హృదయపూర్వకంగా నమ్మింది that he would marry her and consented for a sexual intercourse. Even then, that is not a consent. Therefore, he can be punished under 376 read with 417 cheating. Consension, because right from beginning he had no intention to marry her. It is only to get that consent he has told some sweet words, therefore she gave consent. So under misconception anything is done, that is not the original act, that is not an intentional act. అని ఓల్డెన్ డేస్లో ఏం చేసేవారు, మా టైంలో up to 224 we used to take, if the prosecution established the entire facts, we used to punish him under 376 read with 417. It is equivalent to a rape because consent is not there. No direct consent was not there, but consent was obtained by misconception of fact. Misconception under section 98, section 90 is not a consent. If a consent is given under, what is misconception is defined under section 90 IPC. So Supreme Court, the last decision on the latest decision, that means if a consent is given under misconception of fact, it is not a consent and the man is liable to be punished under 376 read with 417. That judgment was given for your noting that note down 2019 volume 13 Supreme Court cases SCC page 1 for benefit of your students. ఎవరైనా ఆ డెసిషన్ తీసుకుని చదివి ఎప్పుడో రిలవెంట్ ప్లేస్లో ఎక్స్ప్లెయిన్ చేస్తూ బాగుంటుంది. దట్ వాస్ ద లేటెస్ట్ బిఫోర్ దిస్ 2024 అమెండ్మెంట్ అన్నమాట. సో 2019 వాల్యూమ్ 13 సుప్రీం కోర్ట్ కేసెస్ పేజ్ 1 అనురాగ్ సోని వర్సెస్ స్టేట్ ఆఫ్ ఛత్తీస్గఢ్. In that case, the Supreme Court held that if a woman gives a consent under misconception, a false promise is a misconception. That is not a consent. He should be punished for 376 read with 417. So, because there is no suitable section in Indian Penal Code, in the BNS they have introduced a separate section. That is section 69. Now there is no problem. There is a direct section under section 69. Please read out what is section 69. It is very important nowadays. These type of cases will come before the court of law. You have the books with you. Please check in section 69. Sexual intercourse by an employing deceitful means by way of మోసపూరితమైన మాటలు. Deceitful means, whoever by deceitful means or by making promise to marry, I was telling to you, is not it? By making a false, it should be taken as false promise. A false promise to marry, and by believing that one a consent is given, that is not a consent at all. Whoever by deceitful means or by making promise to marry to a woman without, this is most important part of that section, without having any intention of fulfilling the same, as sexual intercourse with her, such sexual intercourse not amounting the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So a specific section is given under BNS. It was not there previously. ఇక్కడ ఏమంటారు, though you cannot directly call it as a rape, but still it can be punished under section 69. 69 takes up the situation of deceitful means, not having real intention, believing that one she advanced with him, therefore later he rebacked from his promise. This amount to offense under section 69. You please study section. You may get questions on this one. Very important one in my esteem. Then like section 95, children, an offense is done through the children. This is also for the first time they have done. If a man, you know that under 18 years of age, if a child has committed anything, it is not an offense and he will be juvenile justice act will so some people are organized crimes will be done, organized begging or what, through children they are doing this, isn't it? There will be persons behind them. They will go to the extent of maiming them and putting them in the begging. That is the situation. Suppose certain organized persons organizing the crimes through the children, pickpocketing through the children, isn't it? Some other offences also getting done through the children. It, now, to meet such a situation, there was no specific section. Now they have made a specific offence under section 95. 95 says that such type of offence shall be punished with 3 years and up to 10 years. 3 to 10 years, minimum of 3 years and maximum of 10 years shall be. Then the another important section I have already stated, 103 subsection 2. అంటే ఏమైనా వాళ్ళు ఏమైనా క్వశ్చన్స్ పెడుతున్నారేమో అంటే వాళ్ళకి ఏమైనా కావాలేమో అని నేను చూస్తాను. సో 103(2) I have already stated mob lynching. Mob lynching was the section introduced for the first time. This honor killings, etc. Isn't it? This type of what, when a group of 5 or more persons acting in a concert commits murder on the ground of race, caste, or community, sex, place of birth, language, personal belief, or any other similar grounds, each member of such group shall be punished with death or with imprisonment. See, if you read this one thing will strike in your mind. A person's a group of 5 or more and then 143 common intention, common object put 5 or more persons doing an act of offense, they will be booked under 149 common object and ustundi. That is a bit different from this one. This main intention is, what is it is to commit murder on the ground of race, caste, or community, sex, place of birth, language, personal belief. So they have carved out a specific offense to the effect that in order to do this honor killings are increasing. A judgment also there, if I try to find out this judgment has come in this honor రాజస్థాన్ ప్రాంతం నుంచి వచ్చిన జడ్జిమెంట్ ఒకటి ఉంది, అది సైంటిఫిక్. సో honor killings, a group will commit murder on the ground of race, but particular religion, one religion against another religion, race, caste, or caste based, race basis, not for money or not for general property. That type of offense is not that. It is based holding a hatred against a particular race, caste, sex, religion. These type of ill feelings based offenses, 5 or more, committing murder, it is called as mob lynching. అంటే గ్రూప్ అన్నమాట, సామూహికంగా గుంపు హత్య అంటారు అన్నమాట. To meet that situation, this is particularly this section is sprouted in the backdrop of to prevent this honor killing. 2 types of different caste people are marrying, or 2 inter-religion marriages are being performed. One group are killing the other groups, etc. To prevent that one, this 103 is brought forth. Then 106, this is another important. 106 subsection 2, hit and run cases. A motor vehicle going, hitting a person, he died, and that motor vehicle without stopping, going away. After some time, if he is found, that driver should be booked. So far, hit and run cases under section 182, etc. comes in Motor Vehicle Acts. It is not specifically made as an offence under this one, what you call hit and run cases. Hit and run offences made a vigorous punishment for the first time under this BNS. What it does, Whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting to a police officer. Escaping. జనరల్గా యాక్సిడెంట్ అయితే ఏం చేయాలి, వెంటనే ఆపేసి పోలీస్ process. A vehicle hits a man on the highway without stopping. That man died, and this vehicle went away. Somehow in future he was found. Then he shall be dealt with under section 106. That is what this section says, that without reporting to a police officer or a magistrate soon after the incident shall be punished with imprisonment, either description for a term which may extend to 10 years and shall also be liable to fine. Of course, this section Act says that this section is still not brought into the book. Act says that section 106 will come into the fore as and when the respective state governments will give the consent, because it has something to pay compensation, etc. Hit and run cases లో ఏ వెహికల్ అసలు హిట్ అండ్ రన్ అయ్యి కరెక్ట్గా మనకి ఒక్కోసారి తెలియడం కష్టం అవుతుంది. If 106 is not brought before section 1 ఒకసారి BNS లో section 1 చూడండి. Section 1, subsection 2. It shall come into force on such date as does it appoint, and different dates may be appointed for different provisions applicable in Samhita. Okay, so for separate provisions of this enactment, the notification has to be given. 106 is concerned, however, section 102 BNS has not come into force with effect on 7/2024. It has not come. 106 is so far has not come into force. To my knowledge, even till today, subject to check it, sir, netlo 106 whether brought into operation or not as a such. To my knowledge, it was not brought into. Section, I have told section 111, 112, 113 or I told sunset laws at this starting. Terrorist and disruptive enactment is there. If that enactment is a sunset law, if it is closed, to save that type of offences, these offences are defined in the BNS. 111 organized crime, 113 terrorist acts, etc. are made as specific offences under BNS. You just read them, definitions. They are equivalent to as provided in Third Act. 113 terrorist act is also
106 subclause to
ఇంకా రాలేదు. అదే that was not brought into effect. అది ఇంకా రాలేదు. So this is the 111, 112 and 113. 111 also organized crimes. Organized crimes are repeatedly robbery, repeatedly dacoity, repeatedly gangster activities, extortion, land grabbing by an organization. And that means కొంతమంది కలిసి రిపీటెడ్గా కొన్ని చోట్ల ల్యాండ్ గ్రాబింగ్, థెఫ్ట్, లేకపోతే ఎక్స్టార్షన్ రిపీటెడ్ సింగిల్ ఇన్సిడెంట్గా చేస్తే ఈ 111 రాదు. ఆర్గనైజ్డ్ గన్స్ వన్ గ్రూప్ అసోసియేటెడ్ అండ్ టు డూ రిపీటెడ్లీ దీస్ టైప్ ఆఫ్ యాక్టివిటీస్ దే ఆర్ కాల్డ్ as ఆర్గనైజ్డ్. అంటే వ్యవస్థీకృత. ఒక ఆర్గనైజ్డ్గా 100 మందో ఎంతమందో తయారయ్యి గుంపుగా ఇటు రిపీటెడ్ what they are called as robbery, kidnapping, vehicle thefts, extortion, land grabbing, contract killing, or other cyber crimes. So these are all taken care of under section 111 and they are made punishment. Because Malimat committee has given, you have to give specific offenses for these organized crimes. Sunset laws is TADA Act. TADA Act, if suppose repealed, that has not been given reenactment, isn't TADA Act is no more enforced. After 2015 or so, 2005 or so, there is no reenactment of it. So to meet those type of offenses, section 113 is given. Okay. Now it is a specific offense under IPC, but the only new thing is to book an offense under that UPA Act or under section 113. The power is given to whom it is given is the superintendent of police, isn't it? Officer not below the rank of SP, superintendent of police, shall decide whether the offence shall be booked under 113 or under UPA Act. UPA Act means Unlawful Prevention of Unlawful Activities Prevention Act. Adokate difference in law. Superintendent of police of a district is given power whether that particular offence should be registered under 113 of the BNS or under the UPA Act. That power is given to him. That discretion rather is given to him, but it is under challenge. You giving a police officer right to book under that act or this act, not to the court, is something bad. Is under consideration, but as the matter stands, the power is vested in the district superintendent of police to decide if such type of offence is committed. Then 113 కింద రిజిస్టర్ చేయాలా, ఉప యాక్ట్ అండ్ సపరేట్ యాక్ట్ ఉందా, ఆ యాక్ట్ కింద బుక్ చేయాలా, పవర్ ఇచ్చారు. That is the only a bit controversial aspect. So these are the new enactments brought to one more important section is section 304. Is not it? Section 304 is chain snatching has become very rampant throughout the country. Chain snatching itself is a punishable offence is made under section 304. Theft by snatching is made. It is a one type of theft, but still it is made because it is very rampant. People are coming on two-wheelers and snatching away, sometimes causing so grievous injuries to women or some other victim. That is why they are making is a very stringent offence, a separate offence, not a general offence of theft. Theft by snatching is made punishable with imprisonment up to 3 years and with fine. This is a separate offence it is made. Then another separate offence is made is section 324 subsection 3. Mischief with the property. We are already there. Mischief is 424 in IPC, isn't it? But mischief with respect to the government property, you make strikes, you make hartals and breaking the RTC buses, public offices, etc. To whom the loss is, not to private persons, to the public property. Mischief with public property is made a separate offence under section 324 subsection 3 for the first time. But it was an offence under a special enactment. What is that special enactment is, you can note down if you want. Prevention of Damage to Public Property Act is another enactment is there. Prevention of Damage to Public Property Act 1984. It is a separate enactment is there under section 3 of that act. If any person during the course of strikes gaani hartalu ninadalu cheskunte stone throwing on the public buses are the victims always, or public office you set fire to it. So causing damage to the public property is a specific offence under section 3 of Prevention of Damage to the Public Property Act. Now it is made as an offence under BA section 324 subsection 3. So these are the new offences that have been under the what you call BNS. Of course, I have told you because of the Supreme Court judgment, section 124, yes, sedition is taken away. Sedition is no more in the book, but section 152 is introduced, akin to sedition. Then section 377 IPC, unnatural offences, that is also removed from the statute book. So for BNS Act, we don't find any akin section. Section 497 IPC is also taken more an offence because of the judgment in that you can note down if you want. Joseph Shiny, SHINE, Shiny versus Union of India, section 2000, 2019, volume 3, Supreme Court cases, page 39. In this, Supreme Court held that it is against the interest of a woman. You are curtailing her right to choose a partner, that is her privacy, also affected by virtue of this section. Therefore, this section should be struck down. Because that's in BNS, we don't find a akin section or equivalent section. It is not. So 124A is taken away, repealed. Section 377 also, because of the another judgment, that is Navtej Singh Johar, versus Union of India. That is also 2019, volume 1, Supreme Court cases, criminal side, page 1. By virtue of that judgment, section 377 is taken away from the statute book. Because that section is not there and because these judgments have come even before the BNS only 2024. These two judgments came in 2019. So those offences are no more in the statute book. BNS, we don't find a equivalent section. So that is how the entire BNS is couched. Original enactment is 511 section. Just a 5 minutes quick review. 511 sections with 23 chapters. BNS is only 358 sections with 20 chapters. That is how it is made. Is each individual offense is not made as a section. Similar type of sections are couched into one single section. That is how they have made it. But few sections are repealed. 124A is repealed. 377 is not taken into consideration. 497 is not consideration. Some new sections are introduced. 11 offenses I have told you. 11 offenses, mob lynching, etc. Section 69, most important one. Deceitful manner in which cheating a woman is made a specific offense. This is how the BNS is brought forth, and finally 358 is that it is a prospective in operation. What section 358 says is, just to look and close the session. It is a prospective in operation but not retrospective. The Indian Penal Code is hereby repealed, no problem. But notwithstanding the repeal of the code referred to in subsection 1, it shall not affect the previous operation of the code so repealed or anything done, duly done, so suffered thereunder. So any case is pending under Indian Penal Code, that has to continue. You have to deal as a lawyer or a judge or a police officer, public prosecutor, deal with that offense as prescribed in the Indian Penal Code only. So the ultimate effect is that BNS is only a prospective. అంటే ఇక నుంచి ముందుకు వచ్చే అఫెన్సెస్కే అప్లై అవుతుంది. Notwithstanding such repeal, anything done or any action taken under the said code shall be deemed to have been done or taken under the corresponding provisions of Samhita. For equalization, అక్కడ 376 కింద ఎవరినైనా బుక్ చేసి ఉంటే దట్ ఈక్వలెంట్ అఫెన్స్ సంహితలో ఏది ఉంటే రేప్ కేసుకి 304 303 ఉంటే దాన్ని ఈక్వల్ అని చదువుకోవాలి. దట్ ఈస్ వాట్. Because section 6 of the General Clause Act says that despite an enactment is repealed, it will operate for the past acts, past activities, past offences. Section 6 of General Clause Act ఒకసారి మీరు చదువుకోండి. ఇంతవరకు విని ఉండకపోతే these type of situations are dealt with under General Clauses Act. General Clause Act ఉంటాయి. Central General Clauses Act, AP General Clause Act. Almost they are similar to each other. Okay. So these are the only salient features with regard to BNS. Because it is a new enactment, we don't get a substantial Supreme Court judgment or Indian Penal Code, High Court judgments. But BNSS, how to deal with it, we have some judgments. BNS, we don't have any major judgments. Have you got any major judgments? So far, no. It's only 1 year old enactment. we didn't have it. Any questions? If you have 5 or 6 minutes, we can deal with any doubt or the manner in which it has to be understood or something, or the persons on students on online. Any doubt with regard to? You are able to understand the main theme of the BNS Act. This is what. Right. Any of them? Test exam.
There are general comments.
General comments, not specific refers to it one. Right. You are a practicing lawyer or you are a student? What is your
Actually, non-teaching staff.
non-teaching staff? Where?
Law college.
Law college. But law college, very good. Your aim is to go for a junior civil judge. Notification lo మీరు already you are already preparing for it. You, madam?
I practiced advocacy.
You are a practicing advocate. Very good. How long since?
6 years, from 6 years.
Huh?
From 2019.
19 onwards. Very good. ఎవరి దగ్గర చేస్తున్నారు మీరు?
Actually, I am from Ongole.
ఒంగోలు.
I have my own office.
You have your own. How come that you have come here, Tirupati?
I am preparing for APPs.
APPs. Public prosecutor. When the examination is?
Notification is there, obviously.
Post
Notification వచ్చినట్టు ఉంది
Yes,
కదా?
Post notify.
Post notify.
Notification.
Notification.
42 posts.
You are not appearing for this junior civil judges examination or not? Why not? You can write as many as similar examinations. Huh? Prepare on the Mamiru. You are right from 2019, you are a well experienced lawyer. మీ పేరు?
Anisha.
అనుష. ఒంగోలు ప్రాపరా మీది?
Yes.
అంటే ఇవాళ ఈ క్లాస్ కోసం వచ్చారంటే ఇక్కడికి?
Yes,
ఇక్కడే ఉంటారు. You can write even district judge examination. So 2019 means already you have completed 6 years almost. 7 years అయితే district judges కూడా. ఏ సైడ్ చేస్తున్నారు మీరు? సివిల్ క్రిమినల్? బోత్ సివిల్ అండ్ క్రిమినల్. Attending district court also?
Yes, sir.
Very good. Strive hard for district judges then. అది పెద్ద గోల్ పెట్టుకుంటే ఇవన్నీ మీరు ప్రిపేర్ అవ్వడం పెద్ద కష్టం కాదు. Do it. Because you have sufficient experience. రెగ్యులర్గా అటెండ్ అవుతారా మీరు కోర్టుకి? You have good number of civil and criminal cases. బిఎన్ఎస్ఎస్ మీద కేసులు పడుతున్నాయా, రిజిస్టర్ అవుతున్నాయా?
Present అన్ని ఐపీసీలోనే ఉంది, sir.
అవి అండర్ ట్రయల్లో ఉన్నవి. అవి ఇప్పుడు వచ్చి 1 year అయింది కదా, ఇప్పుడు రిజిస్టర్ అవుతున్న కేసులన్నీ బిఎన్ఎస్ కింద చార్జ్ షీట్ ఇంకా ఫైల్. చిన్న చిన్న అఫెన్సెస్కి అయితే చార్జ్ షీట్స్ ఫైల్ అవుతాయి, కానీ పెద్దవాటికి అయితే ఇంకా చార్జ్ షీట్ ఫైల్ అవ్వదు. అంటే టు సీ వాట్ టైప్ ఆఫ్ ప్రాబ్లమ్స్ ఇఫ్ ఎనీ దే ఆర్ ఫేసింగ్ in registering the offense కానీ ఇన్వెస్టిగేషన్లో కానీ. In most of the sections and definitions etc. Indian code is replicated in almost main sections. Murder definition కానీ, తర్వాత రేప్ డెఫినేషన్ కానీ, 379 even theft కానీ, cheating కానీ, they have not remarkably changed. Only new sections are carved out. Existing section కొన్ని క్లోజ్ చేశారు తప్ప new definitions they have not touched to my knowledge. I have studied it. I didn't find any remarkable redefining the main sections. ఇదే కదా చీటింగ్ కానీ, క్రిమినల్ మిస్అప్రోప్రియేషన్, క్రిమినల్ బ్రీచ్ ఆఫ్ ట్రస్ట్, ఆర్ రేప్, ఆర్ ఫాల్సిఫికేషన్ ఆఫ్ డాక్యుమెంట్స్, ఫాల్సిఫికేషన్ ఆఫ్ అకౌంట్స్, ఇవేవి కూడా డెఫినేషన్స్ ఏం మార్పు లేదు. మార్క్స్ ఉండడానికి ఏం లేదు కూడా అందులో. Try hard. All the best. To you too, all the best.
Thank you.
Fine. ఇది మీరే. ఇది నా టీచర్. Right.